Judgment in Dr. Nandipha Magudumana's latest appeal case will be handed down next week. Her legal team is seeking to set aside the judgment dismissing her application to have her arrest and deportation from Tanzania declared unlawful. It claims that there are conflicting reports about her extradition. Magudumana says she was abducted by the South African Police Service in Tanzania.
Was Dr. Magudumana consenting to a disguised extradition? To whom was the consent made? We're not told. When was the consent made? Was it after Home Affairs exercised the unlawful power under Section 41 of the Immigration Act to arrest her using a South African piece of legislation in a foreign country? We of course know from the principal arguments that provision is of no assistance to Home Affairs, and we also know that the reliance on the Vienna Convention on Diplomatic Relations is of no assistance. We've made those arguments already. So when was consent made? To whom was it made? Under what circumstances was it made? Is it clear? Is it unequivocal? Is it in writing? None of those facts appear in the answering affidavit.
Legal issues were properly ventilated by our team. I still battle to really, comprehend the notion of informed consent when you are alleged to have told to whom it may concern that you want to go home. To all and sundry, still, it's still bizarre that to all and sundry can constitute an informed consent. We have, in my view, we have done enough to really, have the matter properly ventilated at the SCA. We have the view that another court may reason differently with regards to the issue of consent, particularly on whether or not can a person waive his or her right, a constitutionally protected right, and consent to an illegality. I think counsel for the applicant mentioned, in one of the examples that he cited, that can one consent to a torturous act? Is that really what the Constitution demands of law enforcement officers? So from that point of view, we have the view that really we have done enough to have leave to go and argue this matter at the Supreme Court of Appeal.
How far does Dr. Nandipha want to take this? How willing is she to even go to the Constitutional Court if the Supreme Court of Appeal perhaps doesn't also rule in her favor?
Look, we don't really want to preempt that, to that extent and to that far. We can't project, but all that we know is currently, we are of the view that we have reasonable prospects of success, in respect of our appeal at another court, which would be the Supreme Court of Appeal.
And how is your client doing? It's been a couple of weeks now she's been behind bars. I understand she had a visit from the commissioner, of Correctional Services. Is she satisfied, or does she have any complaints about where she's being held?
Look, obviously she is in custody. The conditions would not be desirable, and those are harsh conditions, but she will be ultimately have to deal with those conditions currently that she's facing. We are busy on the other hand exploring the legal avenues. Yes, but I must indicate that the visit yesterday was unannounced. I'm told it's a routine visit. There was no courtesy of informing the legal team. Perhaps it's in line with their protocols, we don't know. But we'll consult with the client and take instructions as to what came out of that visit, but we will be consulting with our client today.
So lastly, you would dispute any assertion that she's getting preferential treatment where she is?
No, definitely no. I think it's hogwash.
Advocate Neil Slenenberg believes Magudumana will never be able to convince a court that she had sought to remain in Tanzania.
I must admit, what I do not hear and what I do not understand from this argument's profit is why the applicant is said to have consented to an illegality. On what basis? She wanted to come home, she came home. Doesn't suit her, because when she came home, she was arrested at the airport. When did she consent to an illegality, to an unlawful? The moment she acquiesced or consented, there was no unlawfulness, there was no illegality. In the application for leave to appeal, one of the bases for the request that this court must grant leave was said to be that in Mahala in December, the appellate division did not consider the Constitution because they were given before the Constitution.
Now, legal expert Elton Hart weighed in on the case earlier.
If the court now grants her leave to appeal the decision of the High Court that said she gave consent and she wanted to be brought back to South Africa and that consent was sufficient, if the Supreme Court of Appeal grants her that leave to appeal, then obviously there will be a part B to this application where they actually have to look at the actual law and come to a decision as to was the consent that was given or alleged consent that was given, was it sufficient in terms of extradition law and international law standards. And if the court says, okay, no, that was not enough, then it will mean that she would be removed as an accused person, but it will not stop the actual hearing of the other 11, including Thabo Bester in the interim. But it will have a bearing, but obviously it will mean that she will be removed as an accused, but at a later stage she can be added again as an accused person if they now follow correct procedures to arrest her and bring her before court for cases that she is alleged to be involved and an accused person in.